Yes, Richa, the recording has started. We may start.
So first of all, good morning, sir. And
Good morning,
it's
Richa. Good morning, Devisha.
Good morning, sir. It's a pleasure to have you here.
it's with great pleasure and honor that we welcome Dipto Roy Sir with us here. He's basically going to be talking about projects and infrastructure laws and related things. And I hope this interview is very enlightening and it helps our law students and aspiring candidates in this particular area to learn something and to be able to pursue it. So I think we should start with the introduction. Can you please introduce yourself to our audience?
Sure. My name is Deepto Roy. I'm a partner with the Projects and Infrastructure Practice of Shardul Amachan Mangalas. I've been sort of practicing commercial laws for the last 15 years, mostly with corporate law firms. Yeah, that's pretty much.
Thank you for being here, sir. So, while we were actually knowing about you, you have mentioned in your bio that you have completed your LLB degree from NUJS in 2005 and recently completed an executive education from Harvard Law School on leadership in law firms. So, what
Right.
drove you to take this education at this point of time? What is it that inspired you to choose this particular subject?
No, I think it was more sort of as you progress through the law firm hierarchy and as you sort of become more senior in the partnership, there's a change of roles from being someone who executes commercial transactions to someone who not only has to do that work but also has to manage a lot of other different roles, which includes practice leadership, thought leadership, managing the team, sort of managing, sort of making sure that the team is productive and efficient. So a lot of those things are things, sort of you don't naturally learn because you're focused on the technical skills that you require for your work. And it's also that lawyers, because we don't have a background either in management or in commerce, we tend to sort of learn it on the roll, and which is not always the best way to do things. The executive program in leadership on law firms is effectively aimed at partners in law firms across the world, and the intention is to effectively create and make people learn about these structures that are there in terms of management, how to get the best out of your team, how to get how to manage crisis, how to improve, identify and improve your leadership style, how to ensure that at various levels you're taking the right decisions, or at least have a formulaic framework within which you can assess those decisions. So so for me the driver was that I felt that it's something that would be a valuable addition to my role, and given that sort of I've been increasingly managing larger teams and more complex work, having to work across with a number of different individuals, cross team across other teams of the firm, it was something that I thought would help from a theoretical perspective, and that was the intention behind doing that course.
Yes, Richa. So, have we lost Richa? The internet
I
connection.
think she's on mute.
No, no. So, shall we move on to the next question?
Yes, please.
So, as you mentioned in your introduction, that you've been involved in projects and infrastructure since a long time now. So, I I think it would be really great if you could tell our viewers that when did this interest particularly strike you? Was it when you were in NUJS, when you were studying law? Did this come to you then, or it is only after practicing in this field that you wanted to pursue it further?
So, yeah, I think to answer that question, I think I can start with an introduction to projects and infrastructure laws. Unlike some of the other fields of commercial law, let's say competition law or intellectual property, I think at student level, there's not a great deal of understanding of what we do in the infrastructure space. Uh, what differentiates infrastructure law as a practice from most other forms of corporate law, including corporate mergers and acquisitions and other form of corporate transactions, is the fact that there are several characteristics which which are there for the infrastructure practice. For one, all infrastructure sectors have required a great deal of interaction with the government. Secondly, infrastructure is highly regulated, so there is always, so either an independent regulator or rule-making bodies which you have to interact with in day-to-day operations. Third is that there's a high level of public policy and public interest involved. Just one second. Apologies for that. Yeah, so as I was saying, that there's a high degree of public policy involved. So these projects are, from that perspective, always under scrutiny. So if you take a toll road, you would read so many instances where there's a high level of interaction which you have with, toll users, people who collect tolls, things like that. The fourth characteristic of infrastructure projects is that they're highly capex intensive, which means that there's a large amount of initial upfront investment, which makes them fairly risky in terms of from an investment profile. Uh, and and fifthly, you're effectively looking at a significant degree of interaction with external lenders, because whereas a lot of other corporate practices don't involve lender interactions or involve limited lender interactions, project finance by its very nature, is heavily dependent on infrastructure. I think there are a number of things about infrastructure which I liked as including when I was studying. Uh, and part of that is the fact that there is a significant degree of regulation, which means that at all points of time you are within a regulatory framework, and your actions have to be, on the basis of that regulatory framework. Because it is, in a sense, a sector practice and not sort of narrowly defined within the parameters of corporate practice. It also allows you to do a number of things. So, for example, in my practice within infrastructure, I do everything from M&A, investments, bid document advisory, all forms of project contracts, all the way to litigation. So, and which is not something that you would see in ordinary corporate practice, where an M&A lawyer is very easily slotted into a particular type of work. So that is why I wanted to do infrastructure law. I was also, I did an internship in Nishit Desai in my third year, where at that time, the electricity laws had first come out. And if you are familiar with the Nishit Desai internships, and I don't know what they are now, but at that time, one of the things every intern had to do was prepare a presentation which had to be presented before the entire firm. And my topic, for whatever reason, was electricity laws, and that is what I presented on, and that is what sort of then interested me, and which is why I decided to join the projects team when I got into the profession.
So, sir, while looking at this field, the entire branch of projects and infrastructure is divided, can be simply divided into three sub branches. That is, as you said, infrastructure, M&A, projects, and project financing. Could you tell our viewers how these three branches are different from each other, and how do they collectively form one field of projects and infrastructure?
So there are three, as you have rightly identified, these are the three main sub work streams, if I may. And it depends to an extent on where you are on the project cycle. So, at the initiation of the project cycle, when you're just setting up the project, you're effectively looking at, setting up an entity, getting the approvals, consents, and most importantly, most infrastructure projects are through a procurement process run by the government, which is usually a competitive bid process. So the way it works is that you would either, win a competitive bid and be awarded the project, which is done through the means of a long-term contract. And at that stage, you would also be looking at entering into the agreements with the government authorities, and also a number of side agreements for the operationalization of the business, which includes your engineering contracts, your a branch of other contracts that you will enter for setting up the project. And that is in a sense the projects phase, where the main work is around the initial funding of the project, and then uh, around the various project contracts, including, as I said, EPC contracts. That's, if you want to, you can characterize that as the project side of the practice. Obviously, going forward in the project life cycle, you will enter into a number of other contracts as well, including contracts for operations of the project or maintenance contracts. But the primary heavy contractual documentation actually happens at the initiation of the project, in what we call a greenfield project, which is a project that is being set up from scratch. The next level of documentation which we see is when the lenders come in. As I said, because of their nature and their high capital requirements, projects are almost always project financed. And actually, I wouldn't say almost always, it's always project financed. The lenders actually take the higher risk in the project, because they put in 70% to 80% of the capital requirements of the project, which means that project finance documentation, unlike corporate loan documentation, is significantly more complex. Lenders want far more control over the cash flows of the project. They have far more control over the manner in which the project can be operated than you would see in a corporate loan document, or what we call a balance sheet funding document. The other reason for this is also that project finance is almost always what we call non-recourse or limited recourse, which means that your recourse is limited to the project. So the loan gets serviced out of the cash flows from the project. The security provided is the assets of the project. And if the project fails for whatever reason, the ability of the lenders to therefore recover money is fairly limited, which makes project finance, sort of fairly complicated as well. And this is the second stage of the project development, where, the lenders come in, and the majority of the funds for the project are coming. M&A, investment, strategic, these are all sort of in the third life cycle, where the project is already developed, or it's, a fair amount of the construction has been done, or it's already what we call reach commercial operation, which means that the project is complete and it's generating power, or, the traffic has started, or whatever it is that depends on the project. And the project has started to earn revenue. It is in this stage that the project can be acquired by another entity, or someone can come in and make an investment into the project, and buy out a part of the promoter stake. So in a sort of fairly simplistic terms, these are the three major work groups, which is dependent, as I said, on the first, second, and third life cycles of the project.
Right, so I think you fairly described what exactly is this field about and what laws are associated with it, and how it's a very vast combination of a lot of other things as well. So one thing that we've commonly heard about this particular field are the PPP agreements, that is the public-private agreements. So it would be great if you could tell us what exactly these PPP agreements are, and what are the nuances that one needs to look into while drafting one satisfactory PPP agreement.
Sure. So PPP is, as you said, it's public-private partnerships. Most infrastructure. So if you take a step back, when we were looking at the sort of post-independence infrastructure development in India, it was heavily driven by the state, and the state effectively, executed all large projects, including any form of, the big dams, the big power projects. We had these massive PSUs that were put in place, which were responsible for project development. But as sort of as we entered into a liberalized economy, we were starting to look at more and more private participation. The state realized that it does not have funds, and in certain cases the expertise to do project development on its own, and therefore we came up with PPP, which is effectively a partnership between the project proponent, which is the state, and that can be in any form. It can be the central government, it can be state governments, it can be local municipalities, it can be public works departments. It's effectively the state entity, and then you have the private entity which enters into this partnership. The typical way in which PPPs work in India, and right now, if you look at the whole sort of infrastructure space, most projects work on a PPP model. So whether it's ports, whether it's airports, whether it's roads, any other form of sort of complex projects, metro rails, urban infrastructure and management, all of them work on the PPP model, which means that there is a concession which is given by the government for a limited period of time in which you come in and operate, build and operate the project. So there are various forms of PPP. The most common in India is what we call the BOOT form, which is build, operate, own, and transfer, which means that the private party comes in, builds the project, owns it for a certain period of time, operates it for that period of time, let's say 25 years, 30 years, and then transfers it back to the state. So if you take, let's say, a major road highway, you would have the state government give that on concession to a private developer. That private developer will build the road to the extent either build or sort of upgrade the road, operate it for 25 years, collect toll from that, and then at the end of the 25 years, it comes back to the state government on the National Highways Authority of India. So that is a classical PPP model. You have various variations of that. You have sort of only operator models, what NHAI calls the TOT model, which is toll, operate, and transfer, where the road is actually built by the NHAI, but then it's given on an operations and toll basis to the private developer who sort of operates it for 10, 15 years, earns the toll, and then transfers it back. So various models of PPP are there. The characteristic is there. Characteristic is that it has to be a collaboration between the state and the private party, with the private party bringing in the funding, the private party carrying out the construction and the operations, and then reverting it back to the state. That doesn't mean that the state doesn't have a role, even in a situation where, under a boot concession, the project has been given to a private party. The state continues to have to, let's say, provide land, provide access, provide, sort of ensure a number of other contractual obligations. So, give you a simple example. Let's say, I take a concession for a highway, and that highway connects X point to Y point. The reason I would take that concession is because I have a traffic assumption on that point. Let's say it connects two large cities, and I say that there will be so much vehicular traffic between these two cities, and on that basis, I determine a toll rate, and I charge that toll on the users of the highway. And my entire business plan is depending on my assumptions. I may go wrong in my assumptions by 10, 15, 20%, whatever it is, or I may I might may be conservative or aggressive, and my returns will depend on that. But now let's say the state allows a parallel highway to be built, which connects the same two cities, right? What it would do is, irrespective of what my assumptions around traffic were, it's going to inevitably have a significant impact on the traffic. And these are the kind of obligations that the state takes when it gives a project on a concession or a PPP basis, that it would do nothing to change the economics of that project, or it will take specific steps to ensure that the economics of that project is preserved. And that's the state's role. The most important thing about PPP projects in India and across the world, there are two characteristics which you need to always look at from a PPP project. One is that it needs to put the risks on the person who is best suited to manage it. So, for example, the financing risk, which is raising the funds, is best managed by the private party, because they have the sort of the capabilities. They will be able to lean on the banks, and they will have the commercial wherewithal to negotiate the best financing package. Similarly, operations would be on the private party. But if it comes to, let's say, land acquisition, or if it comes to, as I was saying, ensuring that there is no competing highway, those are the obligations of the state, because the state is best suited to meet those obligations. Having said that, there are always situations, particularly in the way PPP has developed in India, where there is a tendency to push all the obligations on the private party, and sort of effectively ensure that the private party takes most of the risk of the project, and that creates some amount of issues. Those are the things we analyze from a risk perspective. And a lot of the economics of a PPP depends on how the contract is worded and where the risk lies. That's number one. The number two in a PPP is the bankability, as we call it, of the document, which basically means that the document should be such that I can take it to a bank and get financing on that basis, which means that there should be a clear visibility of from where my revenues are coming. There should be a clear visibility on how long the contract is for. So, for example, if the contract is for a term of 25 years, what are the circumstances under which it can be terminated before 25 years? Is there a unilateral right on the state to walk away? Can they terminate on default? What happens if there's a force majeure situation where there, let's say, an earthquake which destroys the road? How do I recover my investment? So the contract needs to preserve the bankability, because without a bankable contract, I would not be able to raise funds from an external bank. So if you're, I mean, again, these are fairly simplistic concepts, but I think they're important to understand, because when you look at a PPP project, you are in all forms of PPP, whether it's super complex, urban metro with multiple nodal connections, or whether it's a straightforward road concession, it's the same two characteristics you're looking for. Where is the allotment of risk and whether the agreement is bankable or not?
Okay, sir. So, since you have been involved in this field for over a decade now, where do you think the Indian government and the Indian legal framework relating to the energy sector stand, considering the position of global energy infrastructure and market?
Uh, I mean, you have to obviously look at, and I'm assuming your question involves not just energy, but infrastructure as a sector. I think there
Yes,
are
sir.
varying levels of sophistication depending on where the sectors are. So, for example, power and energy is a sector where the Indian legal system is very sophisticated. We have had since the liberalization of the power sector in 1998, we have set up a very, very robust, independent regulator system. It may not work in all circumstances. There may be, sort of still decision making, which is not, sort of effectively incorporating all forms of commercial understanding that you would expect. But there are regulators in place. There is a appeals mechanism that works. There is a dependency which has moved away from the courts, which is always a good thing. So it's become a fairly sophisticated sector. Whenever you have an outlier decision, for example, there has been a decision by the Gujarat regulator a couple of days ago, where they seem to have taken a stance which seems against a lot of the public policy considerations for infrastructure development, but it's always noted, and there's always discussion. If you have to sort of look at that from the perspective of a sector which has seen less development, let's say ports, the port sector also has an independent regulator. It also has some amount of PPP in the ports, but it's not been as robust and as developed as power, because of the fact that there are lesser number of players, and it's sort of the regulation levels are different. All in all, I would think that sort of from the time I've started practice till today, there's been a significant change in the Indian legal system. I think it's become a far more robust system. I think the court processes have become far more easier for commercial parties. I mean, I'm not going to sort of stretch this to say that all forms of litigation and all forms of dispute resolution has become easier. We clearly have a long way to go on that. But for commercial disputes, I think there's been a significant number of changes. And there have been a lot of legal amendments as well, which has helped this, including, let's say, the amendments to the Arbitration Act, which now requires an arbitration award to be given within 18 months. The IBC framework, which has been developed over the last few years. All of these are positive developments. All of these have led to sophistication in the legal system and their ability to deal with infrastructure projects. Do we compare to a developed country with sort of 100 years of PPP experience? No, and we don't need to, because our problems are also fairly unique. Our regulators are sort of have a lot of other considerations. We have a lot of political considerations which are very, very unique to the country. And as I said, infrastructure is one legal sector where you see a lot of political involvement because of its very nature. You build a road, it's a vote bank. You have a dispute with a road, it's a vote bank issue. When there are accidents on a highway, it's not just the private operator who gets blamed, but the local incorporator as well. So they have an interest in the viability of the road. So So there is a level of localization which is always necessary for infrastructure development. I think the sort of the for me the bright parts is that infrastructure has always been something that successive governments have laid a lot of emphasis on. We have always been looking to sort of find ways in which to make the sector more robust, more investor friendly. Has it succeeded in all levels? Again, no, but it doesn't need to. It just needs to sort of give a standard of development and a standard of how do I put it, consistency in regulation, which allows foreign investors to come in. It's been mixed, but I think it's almost certainly on balance. The developments have been positive.
Right, sir. You rightly pointed out how projects in infrastructure does not only involve a private party, but also how it affects the people in general in the government also, how every government emphasizes on projects in infrastructure. So, as you've also mentioned that while you are in the projects and infrastructure field, there is a lot of other things that are involved. For example, M&A, litigation, and whatnot. So, do you think that dispute resolution or arbitration is a better option to resolve conflicts that arise in this field? Or would you still say that, approaching the courts is a better option?
So the courts is a zero option. I mean, that's absolutely courts are not capable of adjudicating on infrastructure disputes because they neither have the a lot of these disputes are technical in nature. They involve a lot of understanding of the technicalities of, let's say, an engineering contract, or they will be in the nature of regulations where you cannot have a court. You can't apply general principles of equity or sort of the or public welfare which the courts are used to apply. And that's not to say anything about courts. They have a particular role in any sector. In infrastructure disputes, they have very limited role. There can be sort of situations where a government entity is acting high-handedly or sort of is playing around with tender conditions where you have you might have to sort of apply to a high court on a writ jurisdiction basis, and that forms sort of those form the ordinary principles of writ jurisdiction then apply, fairness of behavior and all of that. But on a with respect to disputes which are specific to infrastructure, whether it is a dispute under, say, a power purchase agreement or an EPC contractor, it has to be either arbitration or a regulation. So if you look at, let's say, electricity, you would have a dispute which will happen between the private developer and the distribution companies which are state-owned, and that has to be decided by a regulator because it's not just enough to look at the contract; it's also necessary to see what are the regulations that govern the sector, because that's how you can arrive at a principle which works for the sector. But at the same time, you would also have private disputes between, let's say, the private developer and his EPC contractor, which has to be sort of determined through arbitration.
So, yes, yet do you think there is still a considerable amount of interference by the court, since when you're relying on the arbitration agreement or the contract itself, you do have to take uh, certain things back to the court. For example, there's Section 9 where you again go back to the court. So, do you think all of this interference could be avoided, or is it still necessary?
No, I mean, Section 9 is something that you have to have. I mean, that is a power that courts have to, sort of intervene in circumstances where the arbitral tribunal is not ready. And you can't have a situation where you don't have recourse because, let's say, the counterparty is sitting on your proposal for arbitration. So Section 9 is a power that is absolutely necessary. Courts need to exercise that power. I think the issue wasn't so much on whether there are limited grounds in which courts will always oversee arbitration, whether it's a Section 9 or whether it's a 34 or a 36 for review of the arbitral award or enforcement of an arbitral award. You need courts for that. It's just a question of what is the attitude of courts when they look at an arbitral award, whether they recognize what is their role under Section 9 or under Section 34, and they recognize that it's a fairly limited role, or whether they sort of sit in appeal on the arbitration award. The problem that is there is that judges always tend to think in an expansive manner because of and because of which their intervention in arbitral matters sometimes far exceed their, in a sense, the framework of 34 or 9. Uh, as long as the judges recognize that this is the role that I play in a Section 9 petition, I don't think that's an issue. I think that then works smoothly in terms of your reliance on arbitration. It is for judges who are overreaching that problems are created. Fortunately, I would say that over the last 5 to 8 years, there's been a lot of education around, sort of the courts and their role vis-a-vis arbitration awards. And overwhelmingly, what we see today is that judges are reluctant to step out beyond, sort of fairly limited scope of Section 9 or Section 34, and they look at arbitral sanctity as something that is, sort of in line with international principles of arbitration, which is that once an award is passed, it is only challengeable under very, very limited circumstances, and that is changing the way courts look at arbitration awards. And as long as they stay within the sort of four corners of their right of their jurisdiction under Section 9 or Section 34, court intervention is not a problem. It's when they step out of it and effectively either sit in appeal or sort of look at every action of an arbitrator and pass orders is where there's a problem.
Okay, sir. So before moving on, due to the constraint of Zoom, if at all the meeting might end
We'll
in
done.
another 5 minutes. So we will join the same link again.
Sure.
So actually, it's the last question. What advice would you like to give young lawyers who are interested in this field or would look forward to practice in this field of law?
Sure. So one of the things that I feel quite strongly about is that a lot of people coming out of college get quite fixated about certain fields of commercial law. I've seen IPR, for example, is something people find very interesting, and technically it's an interesting subject. I think something that I keep reminding people is that the practice of law is often not as glamorous in that sense, as theoretically reading about, let's say, certain things on in the textbook. The practice of law is actually, in certain cases, is quite, it requires a lot of effort. It requires a lot of attention to detail. It requires a lot of ability to concentrate, to pick issues. Uh, the reason why I would think that for someone who has a love for the law in very cliched terms, is that projects actually allows you to practice a wide variety of legal practices. It allows you to do sort of almost all forms of corporate transactions. It allows you to look at disputes. It allows you to look at a variety of contractual agreements. It gives you a significant learning in terms of a business, because you can't draft, let's say, a power purchase agreement unless you actually envisage how electricity is generated and sold. You have to break it down. You have to understand the concept. You have to understand how sort of it flows from one part of the grid to another before you can actually effectively execute the contract. So if you are interested in learning new things, it's something, again, which sort of is gives you a lot of learning. uh, and therefore I would say that if you are looking at a practice which is which has a high learning value, which gives you a lot of learning, which allows you to a very, very clear understanding of the business uh, of your clients, I would highly recommend projects, because again, you can be a financing lawyer, you can be a corporate M&A lawyer, and you can be a contract lawyer, and you can do all three within this practice.
Thank you, sir. It was a pleasure talking to you. And I'm sure everyone was enlightened about this very niche and unconventional area of law. And definitely doors have opened up. And we, as young law students, as well as young lawyers who have just graduated from college, will look forward to this field and take interest in developing a career in the same. So it was a pleasure talking to you. Thank you for giving us time from your busy schedule. And yes, thank you so much from Tathya.
Thank you very much. It was a pleasure. Thank you.
Yeah, thank you so much, sir.
Bye.